This is a huge opportunity for people who have accumulated wealth before they got married, or entrepreneurs, or maybe you receive are going. One of the things that I focus on as an estate planning attorney is asset protection. And so there's a few different things that you can consider when it comes to bulletproofing your assets from a divorce. And so I'm going to talk about three things today, and really they should be used in conjunction with one another. So the first one, and I'm not going to talk about it in great detail, but the first one would be a prenup or postnup. And so there's a lot of estate planning attorneys that will draft prenups and postnups. I don't actually focus on doing that just because I spend so much time on another aspect of asset protection. But I work with divorce attorneys, family law attorneys all the time who handle this for clients. And so basically what that is a contract that you have with the person that you marry that says, in the event that there is a divorce, we're going to split our assets according to what we agree in this document. And so again, you can do it as a prenup before you actually have your nuptials, before you get married, or as a postnuptial agreement after you get married. So one of the caveats about this is that you have to be forthcoming about all of the assets that you have, the nature of your assets, how much they're worth. You can't hide any details from your spouse when you're doing a prenup or a postnup. And a lot of times people run into issues because they're not forthcoming. Maybe it's intentionally that you're deceiving your spouse or your spouse to be, or maybe it's just, you forgot something, or you didn't understand how a particular asset was owned, or maybe it was an asset that you inherited, or maybe it was just something that never got talked about during this process of the prenup or the postnup. So the point of bringing that up is that prenups and postnups can often be challenged. And you'll often hear attorneys say, well, they're not worth the paper that they're written on. And I don't know if that's necessarily true. I would probably disagree with that. And I think it's a very valuable tool to have. So that's one aspect of asset protection and bulletproofing your assets from divorce. The other two are really focused on trust planning. So we'll talk about third-party settled irrevocable trust and first-party settled asset protection trust. So historically, when mom and dad or parents would set up an irrevocable trust for the benefit of their kids, and they passed the inheritance to the trust rather than outright to the children, any of those assets that were in that irrevocable trust, some people call it an inheritors trust or a descendants trust, any of those assets inside of that trust were protected from any type of creditor claims, right? So the goal here is not to give an individual ownership of assets, but you have the trust own it, and then the child just has a beneficial interest, a beneficial ownership of these assets, but they themselves don't actually possess anything. And so that was historically been one way that you would bulletproof assets, is mom and dad, parents, would make sure that rather than giving it outright to the child, they would put it inside an irrevocable trust. Third party sets it up for the benefit of someone else. The other thing in that situation, the other thing that the child could do is then sell their own assets to the trust from which they benefit from. And so you have to actually create a legitimate transaction in the eyes of the IRS. A lot of times you take a promissory note, which has an interest rate associated with it that the IRS sets. But that's one way for an individual to get assets out of their individual name into the name of an irrevocable trust. There's tax planning strategy, estate tax planning strategies associated with that, but there's also this asset protection aspect of it. Really, it's complicated. When you start selling, I should say it's not complicated when parents set it up for the benefit of the kids, but it's complicated when you start selling your own assets to a trust from which you benefit from. And usually you're also the trustee on. So you have a lot of flexibility there to manage those assets as well as to benefit from those assets. The other option that you have in the event that your parents do not set up an irrevocable trust for you, or cannot set up an irrevocable trust for you, or maybe you have significant assets in your own name and you can't sell them to an irrevocable trust that was set up for your benefit. When this is the case, you can set up a domestic asset protection trust or a foreign asset protection trust. So what is this? This is what I was talking about a second ago with first settled asset protection trust. So first settled, meaning you yourself as first person set it up for the benefit of yourself. You set up an irrevocable trust for the benefit of yourself. You fund that domestic asset protection trust or foreign asset protection trust with your own assets, which there's different ways to set that up. I won't go into detail about that in this video. But again, the name of the game, the objective is to change the nature of ownership from you as an individual to the trust. Because if you have assets in your personal name and there is a personal creditor against you, such as a spouse who has divorced you, or maybe you've divorced the spouse, then they can go after assets in your individual name. However, if done properly, done correctly, structured the right way, they cannot go after assets that are in the name of an irrevocable trust, even if you benefit from those assets. So one of the things to keep in mind when you're approaching this is this fraudulent conveyance doctrine. You want to make sure that you do the planning before you get married. That's the best way to do it. But unlike a prenup or a postnup, you don't have to disclose that you have this asset protection trust that you're benefiting from. Even though your spouse, once you do get married, can indirectly benefit from this trust because you are sharing those assets with that spouse. But you don't have to disclose everything that might be in that trust. And so this is a huge opportunity for people who have accumulated wealth before they got married, or entrepreneurs, or maybe you are going to receive a business interest, or you're part of a family business, I should say, is probably more likely the better, the perfect situation. You're part of a business, family business. You move your business interest that you have into a asset protection trust. So one of the things to keep in mind is that there's only 20 states with asset protection trust statutes on their books, and really only a handful of them are worth having or worth considering: Nevada and South Dakota. In South Dakota, because of its privacy and flexibility laws, and also its trust protector laws, make it much, much more advantageous than Nevada. The other thing to consider is going offshore. You can look at Cook Islands or Nevis or a few other jurisdictions that are known for having really strong asset protection laws for United States citizens.